everybody, and welcome again to another episode of the Risk Matrix with James Junkin
The Risk Matrix, baby. James Junkin.
and
Roll Tide.
Roll Tide, Roll Tide. Welcome to the new year. We're gonna, we've had a few episodes so far. We want to roll into something that we've kind of already talked about, but maybe more the safety professionals' role, and specifically the safety professionals' role in working with attorneys after SIF incidents. And this is something that James is, very passionate about. He gets involved in a lot. Sometimes I help him, sometimes I don't. But I'm Dr. Martin. And before we get started in that conversation, I'd like to roll it to James over here and he can talk about our sponsor for this episode.
Thank you, Dr. Martin. Yes, this episode of the Risk Matrix powered by Veriforce is sponsored by SiteDocs. As all safety professionals know, it is difficult to maintain a safe workplace using paper or inadequate software. Today, over 3,000 companies use SiteDocs safety management software to help streamline safety operations with digital forms to ensure compliance and safe work in real time. Members of the Veriforce network receive up to 30% savings on your first annual subscription. So to learn more and to benefit from this exceptional offer, visit veriforcenetwork.com/offers/SiteDocs. And Dr. Martin, I'd like to just kind of announce this for the folks that are coming to listen to this episode. If you've not listened to the previous week's episode with attorney Brett Kettercamp from Ogletree and Deacons, I'm going to encourage you, go back, listen to that episode, and that'll prepare you for this episode where we're going to get into the role of safety professionals when working with attorneys, especially during SIF incidents and after.
Sure. So, like I said, James, you're kind of the expert in this. You do this, sadly, quite a bit. You get called into incidents that are either serious injuries or fatalities or both, right? And OSHA's there, and people are rattling around. We talked about this with Brent. What is the role of the safety professional specifically when working with an attorney? And I'm not talking and I know it weaves in, but I'm not talking specifically about as things progress, but what is your role? Because the attorney has a goal in mind, and let's talk. Well, maybe we should talk about the goals first that the attorney has for the client, and then what the safety professional is supposed to be doing to support that.
Well, we typically have two things going when we're talking about counsel in a serious injury or fatality investigation. In one aspect, you may have counsel that's representing you in the OSHA inspection process. Then you may have counsel with your insurance company that's representing you in any type of negligence claim or in a wrongful death claim. Typically, that's covered under your general liability insurance, and the insurance company and you will work together with an attorney that y'all agree on to represent you in that case. So counsel has specific roles in each of those endeavors. What you may find is the OSHA investigation will probably come first, and any litigation may come afterward. Most states, you have at least a year to file your claim, your lawsuit, your civil claim under negligence or wrongful death. Some states it's 2 years. It just depends on what state you're in. So OSHA, though, is going to open their investigation immediately. And typically they wrap up within 6 months. So you'll probably be working with your OSH counsel prior to you working with your insurance counsel. Now, one thing that most people don't understand until they get involved in this is that attorneys specialize, just like doctors. So you're not going to go to a podiatrist if you have a heart issue. So I don't recommend you go to a general practitioner of laws that does, small time litigation, maybe some wills, some business laws, incorporating companies, that kind of thing. When you're dealing with OSHA, you need a specialist. When you're dealing with wrongful death and that type of situation, you need people that understand how to deal with insurance, et cetera. And typically your insurance company is going to have approved attorneys that are on the list. that you can use because they're ultimately paying for that. The other misnomer that people have is that outside counsel is always paid for by insurance. It is not very typical for you to have an OSH specialized attorney that's covered by insurance payments. Sometimes they are, sometimes they aren't. You probably, if I could set a goal for a company heading into 2024, that's something you should resolve ahead of time. All right. That's something you should be asking your insurance broker, your agent. Hey, if we had an incident and OSHA got involved and we needed outside counsel to help us in this representation, would that be something that's covered under our present policy? Many times it's not, right? So the safety professional, though, is going to be put in a very unique situation because they're going to have to work with both sets of counsel. Ones that are representing you in the OSHA investigation, and ones that may be representing you down the road. So you don't have to become an attorney, but there is some basic legal aspects of occupational safety and health things that I think you need to know, and you're going to play a significant role in this, no matter whether there's civil litigation on the part of plaintiff's lawyers representing a client that's been injured or a family of someone that's deceased, or working with your OSH attorneys.
So one of the things that I learned working with a few cases with you recently is at least you're working with other safety professionals that we tend to want to tell people what we know and what we don't know and how smart we are on the investigation and all these different things. And um, one of the things I learned is one, you need to keep the texts and uh, written documentation and the spewing of your knowledge to yourself. And you also need to stay in your lane. Okay. So stay in your lane, right? And I think that's really important that we need to define that because you say that multiple times on meetings that we're on about I'm not an attorney. And similarly, even though they know a lot about OSH concerns, right, and violations and whatnot, and how to go through the process, they are not a safety professional. So explain to me what stay in your lane looks like in a SIF.
So it's really a team approach in each aspect of each role, whether it's counsel or the safety professional, needs to be defined early. Typically, what the safety professional's goal is, we need to find out what happened, why it happened, and put a countermeasure and mitigation in place. Now, just because you're an attorney that practices in the field of occupational safety and health does not mean they know all the regulations, that they understand your safety management system, that they understand your training processes and how everything works. So typically, post-incident, what's going to happen is your leadership team and their counsel's going to look to you to develop an investigation. Number one, they may outsource that to a third party. Like that's how we get involved at Mariner Gulf a lot of times. We're the third party that comes in and does an independent investigation protected by attorney-client privilege. But in many cases, it's just going to be the safety professional that's there. You're there to conduct an investigation and make sure, at least initially, your main focus is we want to mitigate whatever caused this. Mm-hmm. Right? Mm-hmm. So we don't have a repeat accident. Our job as safety professionals to get workers home safe. So let's just assume that we've already done that, right? We've mitigated whatever the hazard was, whatever the exposure was. You know, that can be a variety of methods depending on the situation. I'm not going to go through them all, but it could be, you know, we put up barriers, defenses, retraining, whatever. It's going to be situational specific. After that, though, is when the gathering of information happens. That's called discovery, right? Mm-hmm. And OSHA, and if you end up in a plaintiff's case, the plaintiff's lawyers, they're going to ask for discovery. So what does that mean? They're going to ask for training records. They're going to ask for policies and procedures. They're going to ask for site inspections, your disciplinary program, a whole bunch of information, right? And it's going to be your job as a safety professional to gather it. Somewhere along the line, we've got this idea, because we watch too much TV, that our counsel is going to come in and do all that work for us. They're not going to be up at 2 o'clock in the morning like Aaron Brockovich putting this case together for you. You're going
No,
to have
you
to
are
do
Aaron
some work.
Brockovich. You
You're the
are
Aaron Brockovich, right?
That's right. That's right.
You're the Aaron Brockovich. So preparing for that as a safety professional, I need to be able to put my hands on our training records. So if you don't have a learning management system or some type of documentation system now, you need to put one in place, because one day somebody may ask you to produce all those records, and it's too late to start going through, manila folders. Here's a sheet I got, legal pads, all that stuff. So you're going to be in charge of gathering things like the paper documentation, then the implementation documentation.
Yeah.
Things like site inspections, etc.
Can I interrupt you for 1 second? Because I want to roll back a little bit, right? You said OSHA is going to ask for a lot of things. Okay. And we talked about this with Brent, right? Just because OSHA asks, okay, doesn't mean that they have a right to have everything, right? And by that I mean, like, if it's a fall, right? Then we're talking about falls. That's why they were there. That's why you were being cited. That's right. You're not
Right.
going to give them training records for the entire organization on every lockout, tagout, confined space, all these different things. You're going to give them specifically what is related to the incident, right? Type
Absolutely.
of citations.
Absolutely.
And then the other thing I want to say, and this becomes one of your roles too, and you can correct me if I'm wrong. I've had attorneys say to me, well, OSHA was out there and they didn't really say what they're kind of leaning towards for citations. What do you think, right? What do you think about X? Here's third party, you come in, right? And they show you some pictures, right? And here's where your training, your experience, your education, everything comes in. One of your roles is to start noodling around with the attorney ahead of time, not 6 months down the road when the citations come out, but start noodling around ahead of time. Not only what are the obvious things, but what are the less obvious things? And you should be putting corrective actions in place for those too, but also preparing the attorney with the information to combat what also might come out beyond the fall citation. Is it going to be a ladder? Is it going to be the flooring? Is it going to be I don't know. I mean, you can tell by looking at it with your experience, knowledge, and education, and that's one of your roles, right?
Right. And so to answer your question in two parts, because there are two parts of it there.
Yeah.
The first one is document requests from OSHA. Well, just because they ask for it does not necessarily mean they're entitled to it. That's why I say stay in your lane and you get counsel and have identified counsel as to who we might use when this happens. I cannot emphasize this enough. Fatalities are not calendared. Serious injuries are not calendared. We don't know that, hey, 2 weeks from now, we're going to have this event. You have to report to OSHA within 8 hours. The next day, an inspector is going to be on your site conducting this inspection. And you're going to get requests. And what I commonly see is we have an incident. We didn't have a plan. We're overwhelmed. The compliance officer comes out. They do the inspection. They walk around and they take pictures. We don't take pictures. We don't go through and do sampling. We just kind of wander around with them. We get a document request that says, send me everything in your organization. We send it in, and then we have that. Remember that?
I should have, could have, would have.
I should have had a V8.
Yeah. Yep. I should have, could have,
we have that moment and we start getting scared, and then we call counsel. I'm not saying it's too late, but you've already opened the door potentially for a lot more serious citations and exploration and more things that the compliance officer can look at, whereas you could have kept it focused. So number one, get counsel in earlier, right? Number two, related to your comments about getting organized there when we get to that point where we're working with counsel, don't just send people everything, right? You can expand these inquiries, and that's why it's important to have counsel to deal with that. Let the lawyers and OSHA deal with what you're going to give them. You're the safety professional. Let lawyers practice law and you practice safety. Now, one of the things that I do, and we do at Mariner Gulf, and a lot of people do, is try to determine what the most likely scenario is going to be from an OSHA inspection. In other words, where are they most likely going to cite us? It is what it is. Okay? It is what it is. So that's why it's important to get the information to go with the compliance officer, have the opening conference, right? Why are you here? We need to determine that. If it's a SIF incident, we know why they're here. Walk with them. Take pictures with them, right?
If they take a picture, you take a picture
from the same angle, right? Make sure you have what OSHA has. They may want to interview employees. This is why you have counsel, right? You don't want people just being pulled off the job site. They have rights. You have rights. OSHA has rights. Let counsel organize how these interviews are going to take place. It's too late after we've already done the interviews, right? Now, we have rights that we can sit in on management interviews, but employees can meet with OSHA privately, or they can ask for representation, or they can tell OSHA they're not meeting with them. Now, you can't have what I call undue command influence where we're telling our employees not to do that. You'll get a super citation for that. But it needs to be organized. And that's what counsel does, right? That's what counsel does. Now, from the sense of me as a third party looking at this, or an internal safety professional, just like we do an incident investigation to determine what happens, we also do an incident investigation to determine what most likely we will be cited on. OSHA can only cite you against a standard. Okay? So, knowing what those might be, what I like to do, and I recommend safety professionals do, is go down there and let's say if it's a fall protection issue, you know we're going to get cited probably 2 or 3 times under the fall protection standard. If it's a chemical, you know we're going to the HAZCOM standard. Where are your gaps? Did we train them? Are we going to get something on that? Did we not have safety data sheets? Okay, did we get something on that? Figure out where your weaknesses are and then develop a corrective action plan.
Immediately.
Too many times, Dr. Martin, I see safety professionals waiting and companies waiting until they get the citations in the mail, then going to the informal conference and with a bunch of we gonus.
Yep.
Okay. It looks a lot better and it helps with your negotiating power, which we're going to talk about here in a moment. Your negotiating power, if you recognize your deficiencies and put corrective actions in place.
Before you go into that informal conference.
Because that informal conference might be 6 months after the incident.
Right.
So from a safety professional standpoint, we need to know where our gap is so we can close it, so we can keep workers safe, which is our number one priority. We don't want to have a repeat of an incident. And 2, we want to demonstrate that we do care about the OSH Act. We do care about our workers, and we want to put corrective actions in place, right? Then document what those corrective actions are. So if it's retraining, it's retraining. So what do you need? I need to have the training material that we use to train, the qualifications of the instructor, and documentation of who was trained. Now I want to
And
say
it's
this about training, and then you can jump in and whatever, because I'm fixing to get preached.
okay, you're
Okay?
already preaching, but go ahead.
Retraining is not the exclusive remedy for every situation. Okay. It's
Totally
the
agree.
default that I see a lot, particularly in non-serious injuries and fatalities. We have to turn an investigation into a hiring client, and we blame the worker, and then we say we're going to retrain the worker, and we bring them in and we retrain them. And training wasn't an issue to begin with. It wasn't they didn't know, right? Our investigation was very, very superficial, and our corrective actions
Right.
very superficial. That's not going to fly with those,
Right.
right?
And I really wasn't going to say anything extra there, James, except for the standards are very specific about what needs to be done. So there are some trainings where there needs to be a signature, right? There's some trainings where the like you said, the instructor has to be identified. The content has to be identified. The content has to follow a certain content outline. Sometimes, like when you get to HAZWOPER, there has to be specific things in there. And they can cite on that, right? And sometimes they'll cite several times right within one section
They
of a standard,
they will
right?
stack. They will stack citations on top of each other that come out of the same subpart.
And your defense, if there's no defense, is that you've been proactive during that time while you were waiting for them to come back with what the citations were. Because honestly, James, and I don't know if you feel this, but sometimes there's no defense, right? I mean, you could find a defense
And,
that's a counsel thing, right?
right.
Sometimes there's no defense, but when there's no defense, your best offense to be offensive is to go in and start correcting things proactively.
The most in most situations that result in serious injuries and fatalities, it happened. Okay. The
Mhm.
employee is injured or the employee is dead. Something went wrong within the safety management system.
Mhm.
Practicing good risk management inside an organization, I need to determine that. If everything was perfect, this never would have happened. The question whether it's citable by OSHA or not is really what comes down to the investigation, your advice from counsel. But in most cases, something occurred and we need to put a countermeasure in place. And it looks a lot better and it's morally justifiable and necessary to do that now and not wait 6 months until OSHA tells you to do it. So part of
Agreed.
the safety professional's role, I think, is identifying what occurred, right? And putting a corrective action plan in place. So your first role is probably going to be document discovery and also, hey, mitigation efforts to prevent immediate reoccurrence and protect life, property, and the environment. Then, hey, what did this happen? How deep can we go in this investigation? This is what occurred. What are our potential citations that we think we're going to get? And from that, the steps that we're going to do to mitigate and alleviate those citations to bring this company into compliance. For example, if I go out there and we have an issue, I'll give you a real one. We had an issue where an employee was killed in an explosion. Another one seriously burned. Well, obviously, we had an ignition source within 35 feet of a combustible material. That's one citation. But then where did that material come from? Now we're getting into HAZCOM. All right. So did we adequately provide a safety data sheet for that? Did we train those people? You see what I'm saying? So you can't just focus on that one event. You've got to look at other areas that contributed to that event, and they're most likely going to be citations. If you want to go up against OSHA and say, hey, please lessen these penalties or withdraw some of these penalties, you need to begin with a strong mitigation plan. And your counsel's not going to be able to tell you that. You have to do that. You're the safety professional. That's your role. right? That's your role.
Right. So, I mean, at some point, right, you're going to get into the conference and you're going to support the attorney. I mean, I always see that the safety professional, you have an important role, but you have a supporting role when it comes to the violations and how the attorney handles them. And you're the Aaron Brockovich in this situation, and you're handing things to the attorney, and you're trying to prepare the attorney from a safety point of view of what your thoughts are, what the angles are, what the OSHA area director is going to come in and say, those types of things. And then they're going to handle the actual, well, for the most part, they're going to handle that conference with your help. Okay. At some point, OSHA's going to delete the citations, lessen the citations, keep the citation. You're gonna get something. There's gonna be a final decision.
Right.
Um, Short of going further onto the review commission, if you think you've really got a case, right? When does the attorney phase out?
Typically, most cases are resolved at the informal conference. So if I back up a little bit, we are taking some assumptions based on our education and experience of what your potential risks are for citations, right?
Right.
And you've got a big old book to go by most of the time, the OSH Act 1910, 1926. You don't have to be a Matlock, to show my age, or Matlock or Perry Mason to figure a lot of
Right.
this out. We did it, and here's where our potential exposures. Our employees did this, and here's where our potential exposures are. But eventually, it's no longer a hypothesis. You will get something in the mail from OSHA, and it's going to be a notice of proposed citations and penalties. You have 15 days after that to request an informal conference. You should always request an informal conference. And if you've done your preliminary work well, which is what was the hazard, what was the exposure, where's our potential risk right here, and we put a mitigation plan in place. If you do that ahead of time, you're not under the gun, so to speak, to try to do it all in the next 15 days in response to what OSHA says the citations are. Once we get the notice of citations, this is when the safety professional works with counsel and says, they're wrong on this, on the facts and the law. The attorney's going to say the law, we're dealing with the facts. We did not violate this. I have documentation for it. I just had a case where they cited us and they said we didn't turn over training records. And I've got 3 years worth of training records. Just because OSHA says it doesn't mean it's right. Compliance officers are overworked. They're often, a lot of them are brand new and don't have a lot of experience. They have multiple cases going on. They're human beings. They
have
make
areas of expertise, right?
Absolutely. I'm an oil and gas construction manufacturing safety consultant, and I dabble in other areas. This compliance officer might be at a big box retail store one day and on an oil and gas site the next day, then out doing construction the following day. So they have a lot going on. And so when they issue those citations, they could be wrong. And if you can prove they're wrong, they'll withdraw it. So part of your role as a safety professional, I think, is assisting counsel in determining whether they're correct or not. And saying, we will accept this citation, or no, this is what we're going to do for this citation. Okay. Now, I'll get to your question in a moment. The informal conference is showtime. This is where you're talking to the area director. And you and the attorney need to have a plan of who's going to present what. All right. And what I like to do is I like to have a PowerPoint presentation that includes all the documentation that supports either our defense, that they're wrong, or yes, you're right, but here's what we've done to mitigate it. You're correct. You cited us. We did not have adequate training in fall protection. So here's what we've done in the last 6 months. We recognized this was a gap. We sent people to train the trainer to be competent person fall protection instructors. We've trained all of our people in this. This is the documentation for that. And here is the excerpt from the presentation that we use and hands-on evaluations and etc. Put that in your presentation, right? Put that in your presentation. And then they're either going to withdraw citations, lessen citations, or lessen penalties or combination, right? And that's why I think people get really confused. You can negotiate with OSHA. And my experience has been you can still exert your rights and put up a strong defense, but if you show you actually care about the workers and you're putting mitigations in place and you're trying, they will work with you. They will work with you. Can I ask your question again about post-informal conference? When does the attorney
Post-informal short of saying, they're still wrong, right? OSHA's still wrong. They're citing us for something. The penalties are high. We've done all this stuff. They're not citing on the right standard, or they shouldn't. There's not a standard to cite. Short of that, taking it to court with the OSHA review commission, right? Short of that, when does the lawyer phase out? And I asked this question because at some point that phase is going to go away and you're going to be left with citations. Let's say they're not deleted. You're left with citations and now you're being sued. Okay? Because there's something in place that shows that you were somewhat in the wrong or there was something violated, and the deceased family or the seriously injured worker is now going to file a case against you. When do you take it out from under a attorney-client privilege? And I know you've already told me the answer to this. The corrective actions that you're doing to protect yourself in a civil lawsuit, and how do you move forward, right?
Okay.
Because now you're going to have to protect yourself in another way, in another court of law, in another
This is why
purview.
you do not want to just give everything that you have in your whole safety management system to OSHA. Okay. OSHA is subject to Freedom of Information Act request. Plaintiff's counsel can ask that, and everything they got, they can turn over with some exceptions, right? And your counsel can explain those exceptions to you. So you got to start thinking about these exposures when you're delivering things to OSHA. Your OSHA attorney will phase out at this point once the citations are determined, and we're not going to appeal to the review commission and all that other stuff. So we've settled at the informal conference. Now, the privilege that existed with that counsel, you have to reestablish with your other counsel. Okay. And they will work through the discovery, and that's a lot more formalized process. There'll be interrogatories that need to be answered. There'll be discovery requests that'll need to be answered. It'll probably be a lot broader and more complex process than what you had to deal with OSHA, right? Because we're talking about two different aspects of the law. Right, OSHA is only under the OSHA Act. Mm-hmm. Now, for most part, workers' compensation is an exclusive remedy unless you can prove negligence. So that's what we're going to be looking for on your part. Were you negligent? But the same process pretty much applies, right? Our goal as safety professionals is not to prepare for trial. That's what our lawyers are for. Our goal as safety professionals is to put mitigations in place and to demonstrate that, yes, we had a problem and now we've addressed it and workers are going to come home safe or not. That negligence bar is a high bar, right? From a safety professional standpoint, in dealing with those type cases, you're still in the discovery phase. You're going to have to answer questions. You may have to testify. You may have to give depositions. You still want to limit your conversations and outside of official conversations, because those things can come back and bite you. Now, here's the other part of this whole thing. Eventually, these cases get settled, resolved in one manner or another. Your main role as a safety professional, and I warn all of my clients of this, do not have another incident. Okay? Do not have another incident. Because now, if you're dealing with OSHA, that is a repeat incident, right? You're a repeat offender. And so the citations and penalties get enhanced. If we get into a willful, you knew about it, we had an incident 2 years ago, you said you were going to do all this mitigation and abatement, you told OSHA you had mitigated and abated, and we turned around and had this same incident again, get your checkbook out.
Yeah. So follow through.
Absolutely.
There needs to be follow through. And a lot of times, here's what happens, right? You get through with the OSHA attorney and whatever happens, and you go through settlement and whatever happens, and then the employer says, because this has happened with clients of mine, they're just like, okay, we're done. And part of the safety professional's role there is to say, we're not done. And here's why, right? For all the reasons you just said, James, that if this happens again, if we don't correct it, if we don't correct other things in the facility, when OSHA comes back the next time, they're not going to just be looking at one thing. They're going to look at all things, and they're going to look to expand their investigation, because as a repeat offender, there's probably a pretty good likelihood that there are a lot of other things going wrong in that facility. So your role is to be proactive, and also, the main convincer of management to do the right thing and keep, pushing forward and making the place safer, and mitigating those hazards that you said you're going to mitigate.
You're right. Too many times I see people go through this initial process with OSHA, get to an informal conference, and start off with 10 citations, and we reduce it to 1 citation and have $100,000 worth of penalties. Now it's reduced to less than $10,000 penalties, and everybody spikes football and says, "Hey, touchdown, great!" And for that company, it is, but it doesn't end there. If you have another incident, that can be a repeat offense. And now we're talking about, is it willful? And willful, coupled with a fatality, can be prosecuted. Now we're talking about the Department of Justice and the FBI. So what is the role of the safety professional? Hey, man, stay focused. Stay focused. Nobody wants anyone to get hurt. No one wants anybody to get killed. Put the mitigation plans in place. Continue the mitigation plans. Remember why we got here, and we never want to go back there again.
Keep moving forward.
Keep moving forward.
So on that note, James, unless you have something else burning to add to this episode, I'm going to say that's a wrap. What I would suggest, right, if you're not skilled in these areas, is to call in a third party. I know James. I can't recommend him more highly than I can recommend him here. Mariner Golf does a lot of this work. James is very skilled at this. You heard Brent, the Kettle Camp, from Ogletree Deacons on our previous episode. 2 great resources. Even if you don't go with them, call them up, get their ideas. You might find pleasantly that getting that third party on board beforehand, just to have them answer the phone at 10 o'clock at night or in early in the morning, it gives you a peace of mind. It might be worth it. So give James a call at Mariner Golf. You can also reach out to me. I do the same thing, but not as skilled as James, obviously.
Don't know that.
But we, again, well, again, this is another episode of the Risk Matrix powered by Veriforce, and I'm going to let James take us out.
We appreciate the fact that you're viewing or listening to this podcast. We do it for you. We're on YouTube. Go over there to the Veriforce YouTube channel. Hit that subscribe button. Smash that like button. Make sure that you're notified when these episodes drop. You can do the same thing at Spotify. where we're in podcast format. You can still see us on Spotify, but it makes it easier when you're driving down the road listening to us to come through the Spotify channel. Subscribe to that as well. These episodes come out every Tuesday. We look forward to the discussion and your participation. Until next time, y'all keep bringing those workers home safe and roll tide.